Mr. Lewison.
Sir, one of the key amendments in this bill is to make community sentences available to a wider range of offenders. Community sentences provides our criminal courts with alternative sentencing options. They focus on rehabilitating rather than punishing the offenders. This proposed amendment is just one example, which indicates a more holistic and reformative approach to criminal justice. This is a welcome change. There are instances in which the full brunt of society's condemnation of an offence must be brought upon a particular offender. However, it must not be forgotten that rehabilitation is aimed at changing the root causes of the individual's criminal behaviour and should always be foremost in mind. Moving forward, can I ask the Minister whether we will eventually let the criminal courts decide in which instances a community sentence can be imposed? Can I also ask if, in line with the spirit of these amendments, will the Minister considering providing our criminal courts with more alternative sentencing options? A recent case illustrates the difficulties that courts faces because of limitations in sentencing options. The judge will be releasing written grounds, and what I will discuss is informed by media reports. In this case, an individual was convicted for sexual assault and rape of a 16-year-old girl and sentenced to reformative training. There are some who may consider this a light sentence. They may change their mind when they learn the offender was 14 years old when he committed the offence and has a low IQ of 61. I do not for one moment suggest that the actions of this young offender should be minimized in any way. His actions have severely traumatized a young girl, and she is likely to remain scarred for life. What is notable from the press reports is the difficulty the judge faced with the limited sentencing options that were available. In this case, the defense lawyers asked for reformative training. The prosecution asked for a jail term between 15 to 18 years with at least 15 strokes of the cane. The prosecution argued that the offender lacked the requisite cognitive abilities to understand the programs because of his low IQ and was unlikely to benefit from reformative training. I'm not sure, though, if this is a signal that we want to send out as a society when dealing with such an offender. Ultimately, Justice Wu had said that this case had exposed larger issues at stake, including limited sentencing options available to a court faced with a young offender who has some intellectual disability. I would thus like to ask SMS if this concern can be addressed, and whether we are looking into the sentencing options available to a court faced with a young offender with some intellectual disability. Next, on this bill, I'm supportive of the amendments to the victim compensation regime, which makes it easier for victims to obtain compensation through the criminal courts, increase victim participation in the compensation order process, and allow dependents to obtain compensation in certain cases. The effectiveness of the regime will depend on how easy it is for victims and the dependents to navigate the process. As such, can SMS elaborate on the procedures for seeking compensation from the criminal courts? Can I also find out if there will be a limit on the compensation that can be ordered? Further, can SMS clarify the rationale for limiting criminal compensation for a deceased victim's dependent to funeral expenses and bereavement? So the next one has created a fair amount of concern amongst members of the public, which SMS has clarified slightly. Can she clarify further the rationale behind Section 83(2), which departs from the current status quo where a woman is searched by a woman officer? What checks will be in place to ensure that such searches are made with strict regard to decency as provided under Section 83(3)? Next, lawyers have raised to me the concerns that the threshold for reopening the criminal cases is too high, as fellow members have raised previously. The impetus behind instituting the review application framework seems to be to prevent the opening of floodgates to applications to reopen cases. However, it bears noting that when seen in context of all the cases that go before the court, the applications to reopen cases are few and far between. While finality of proceeding is a key concern, ensuring that miscarriages of justice do not occur is a compelling consideration. Can SMS clarify that the new review application framework should not be interpreted to allow floodgate arguments to always prevail, and that consideration of justice and the prevention of error should be given due weight, even at this late stage of the proceedings? Next, I do welcome the introduction of video recording for some police interviews, as it ensures greater transparency of the interview process. It deters the use of coercive practices by investigators, deters false claims of involuntariness, assists judges in more accurately assessing the voluntariness and accuracy of statements made in custody, and increase the public trust in the police. However, these benefits can only be achieved if proper safeguards are put in place. Video recordings will only reduce instances of false confessions if it captures the entire interaction between interrogator and accused. In the words of Professor Michael Hall, quote, "The purpose of such a scheme is defeated if the whole interrogation process spans across hours, but only a portion of the statement or confession was recorded on tape." End of quote. Will SMS consider including in regulations or guidelines on the use of video recording the requirement that the entire interview must be recorded, and that the police do not engage in unrecorded pre-interrogation exchanges or preliminary interviews with the suspect, except where absolutely necessary? Studies have shown that footage primarily focused on the suspect causes a camera perspective bias, where viewers are given the notion that the statement was voluntarily given even when it was not. Will the minister consider including in regulations or guidelines that the footage should have equal focus on both the suspect and interrogator, and ideally also show the full extent of space in the room? Lastly, for this point, I note that only rape under Section 3751A has been listed as an offence for which statements must be video recorded. Will the minister also consider making video recording mandatory for all offences punishable with death or life imprisonment, and for all vulnerable suspects, including juveniles, the elderly, the cognitively impaired, or the psychologically disordered, regardless of the alleged offence? Vulnerable suspects are exceptionally vulnerable to giving false confessions and should be given special protection in the investigative process. Next, this point relates in part to the rationale behind the Evidence Amendment Bill, that victims of sexual and child abuse offences require special protection. Aside from mitigating the trauma of the trial process on these particularly vulnerable victims, will the minister consider enhancing the penalties or creating new offences where children are preyed on by online predators? The ease of access and anonymity of the internet heightens the susceptibility of children to exploitation by online predators. Next, the Evidence Amendment Bill seeks to introduce a new section, 154A, to the Evidence Act to restrict two things. First, the questions that can be put to the alleged victims, and second, the type of evidence that can be adduced about the alleged victim. My first query relates to the type of questions that can be put to an alleged victim. There is currently a provision under Section 154 of the Evidence Act to prevent such questions from being asked of an alleged victim. Can I clarify what questions the proposed Section 154(1)A will cover that do not already fall under the scope of Section 154? Can I also clarify if the combined effect of Section 154(1)A and Section 154(A)(2)(c) is intended to stop questions before they are even asked? If so, I'm fully supportive of the amendment, as the mere asking of a question is sometimes enough to provoke trauma in an alleged victim. This is lacking under Section 154, which only prevents questions that have already been asked from being answered. My second question on the scope of sexual offences under the new Section 154A. The type of offences that are considered sexual offences are set out in Para 2 of the new first schedule. References there is made to several offences under the Penal Code and the Women's Charter. Most of the offences related are capable at first sight of being considered of a sexual nature. There are others which are not as clear. For instance, there is reference to Section 356 of the Penal Code, which criminalizes the assault or the use of criminal force to commit theft of property committed by a person. While I can understand that in certain cases, the prosecution prefer a charge under Section 356, where sexual violence was used in the course of committing theft of property because of ease of proof, this also casts too broad a net, as there may be other cases that do not involve violations of sexual nature. Can SMS clarify that an offence which will not be deemed to be of a sexual nature just because it falls under Section 356? Sir, notwithstanding all of the above clarifications, I do stand in support of both bills.